It's my privilege to introduce the next panel, which will address current issues relating to unreasonable search and arbitrary detention under Sections 8 and 9 of the Charter. In the middle of the panel is the Honourable Mr. Justice Labrosse of the Court of Appeal. His Lordship was appointed to the High Court in June of 1975, I believe, after some 13 years in private practice, primarily civil litigation, but I understand enough criminal work just to keep his hand in. He served on the High Court for some 15 years before being appointed to the Court of Appeal in July of 1990, and it's always a pleasure to appear before his Lordship, even when he doesn't agree with the position that counsel advanced. He's been one of the members of the Court of Appeal who've been involved in a number of judgments dealing with search and seizure, and authored the Court's judgment in Zamet, which I'm sure we'll hear about during the course of the panel, and we're grateful to his Lordship for taking the time to participate in the program. To his Lordship's right is Mark Sandler, who's been a criminal lawyer for some 13 years. He's presently a partner in the firm of Cooper, Sandler, West, and Skirka, and he's a specialist in criminal litigation. He's presently senior counsel to the League for Human Rights of the Brede Brith, and in that capacity he's appeared in the Supreme Court of Canada on a number of significant constitutional questions dealing with hate propaganda, most notably perhaps Zundel and Keegstra. He's also counsel in a number of other recognizable cases, of course, with his partner, Mr. Cooper, the Susan Nels case, and what's billed as the longest-running criminal trial, the Burnett tax prosecution.
It was surpassed by an axe murder case in California, I'm told.
Oh, well, there you go. To my immediate right is Renee Pomerance, who's counsel with the Crown Law Office Criminal, and has been so since her call in 1989, and has a special interest in search and seizure issues. She regularly lectures to groups of justices of the peace and police officers on this topic. She's also argued a number of the leading cases dealing with search and seizure, most notably Fagan dealing with digital number recorders, Teste, the blood samples case in the Supreme Court of Canada, and Colarusso, which is presently under reserve, dealing with the constitutional validity of Coroner's Act search warrants. And of course, you can see from the materials that she's put together a tremendous paper on this issue, and I recommend it to you very highly. It's also very current, including even the most recent Supreme Court of Canada's on this subject in Plant and Wiley. So with that, I'll turn this over to Mr. Justice Labrosse. Over.
I think that the starting point is what is referred to in the book as Chapter C, the excellent paper that's been prepared by Miss Pomerance. Excellent, a little crown weighted in certain respect. Hopefully I may draw your attention to a couple of points. And what we propose to do is to state a number of questions and ask these very distinguished practitioners to comment on them, and I may add my two bit at the end. Those of you who are involved in this field of law know the impact that has been made by the decision in Mellenthin, and there's no doubt that it represents a major development with respect to Section 8. And the first question that's being asked is, can the police conducting a random roadside check stop, in the absence of any reasonable grounds for doing so, interrogate a driver about matters other than those related to the vehicle or its operation, and search the driver and the vehicle? Ms. Pomerance, we'll start with you.
Well, that is the very question that the Supreme Court of Canada answered in the Mellenthin case, and the answer was very clearly no. In the wake of Mellenthin, the police cannot now use the random check stop power as a basis for conducting either a general interrogation of the driver or a general search of the driver and or the vehicle. In a sense, the Mellenthin case really demonstrates the interaction between Sections 8 and 9 of the Charter, while the focus of the court's judgment was very clearly on the search of Mr. Mellenthin's vehicle. The basis for the detention, which had preceded the search, proved to be a highly significant factor in the court's Section 8 analysis. The basis for Mr. Mellenthin's detention, as most of you will know, was, of course, the random check stop power. And it may be helpful to set the stage for Mellenthin by looking at some of the earlier Supreme Court of Canada authority dealing with that particular police power. It is well established by cases such as Dedman and perhaps more particularly Hufsky and Ladouceur that random stopping of motor vehicles for checks of mechanical fitness, sobriety, and the like gives rise to arbitrary detention in contravention of Section 9 of the Charter. By virtue of this police power, police can assume control over the movement of a motorist by way of a demand or a direction. There are no criteria for the selection of drivers. They are selected at random on the basis solely of the discretion of the police. And these elements really combine to create arbitrary detention. While noting an infringement of Section 9, the Supreme Court of Canada was prepared in Hufsky and Ladouceur to uphold random vehicle stops as a reasonable limit under Section 1 of the Charter. This Section 1 rationale was premised largely upon the compelling societal interest in curbing needless deaths and injuries on the roadways. Random vehicle stops were seen to be necessary to ensure effective regulation of driving activity. Another component of this Section 1 analysis applied in Hufsky and Ladouceur concerned the very minimal nature of the intrusion, which is attendant upon your typical spot check. In Ladouceur, Mr. Justice Corey noted that these stops are generally of very brief duration. They involve production of just a few documents and are on the whole minimally inconvenient to the driver. And accordingly, the infringement is really proportionate to the underlying justification. It's interesting to note that in Ladouceur, Mr. Justice Corey noted that were a check stop to involve an intrusive search of either the driver or the vehicle, that search would likely be subject to challenge as infringing Section 8 of the Charter. And in a sense, those words almost anticipated the scenario that later came before the court in the Mellenthin case. It may be that many of you are aware of the facts of Mellenthin. Mr. Mellenthin's vehicle was pulled over pursuant to a random check stop program in the province of Alberta. It was after midnight. And the procedure continued without incident. He produced his driver's license, his vehicle registration, his insurance documents. And thereafter, the officer shone a flashlight inside the interior of the vehicle. And it was at that point that he saw an open gym bag on the front passenger seat of the car with a paper bag inside. The officer asked what was in the bag, and he was told it was food. But he detected a glint of glass, which led him to suspect that perhaps narcotics were present. I suppose he thought maybe there were glass vials in the bag. He asked that it be produced, and indeed it did contain glass vials. This prompted him to search not only the bag, but the entire vehicle, at which time he found narcotics. The unanimous judgment of the 5-member court was once again written by Mr. Justice Corey. Mr. Justice Corey held that the questions about the bag, the search of the bag, and the search of the vehicle were all elements of a search for the purposes of Section 8 of the Charter. And this search was found to be unreasonable and in violation of Section 8. In this regard, the court noted that the officer did not have reasonable and probable grounds. Indeed, he didn't really even have a suspicion that he would find evidence of crime at the time he asked the questions and conducted the searches. And ordinarily, the absence of reasonable and probable grounds will itself lead to a finding of unreasonableness. But when one looks at the Mellenthin judgment, it's clear that what was really at the heart of the court's concern was the fact that there had been an exploitation and unwarranted extension of the random check stop power. This was made very clear by Mr. Justice Corey, in which he stated in his judgment that the police use of check stop programs should not be extended beyond those aims, that being to check for sobriety, mechanical fitness, and the like. Random stop programs must not be turned into a means of conducting either an unfounded general inquisition or an unreasonable search. This concern of the court was also made apparent during the course of the Section 24-2 analysis, and once again in this context, Mr. Justice Corey reiterated that a check stop does not and cannot constitute a general search warrant for searching every vehicle, driver, and passenger that is pulled over. So the very clear conclusion that one can draw from the Mellenthin judgment is that random stops cannot permit random searches. And unless there is some other basis for conducting a search of the vehicle, be it perhaps the Plainview Doctrine or reasonable and probable grounds, the seizure of evidence will undoubtedly be found to violate Section 8, and the evidence will more than likely be excluded under Section 24-2 of the Charter.
Mark?
Well, just one comment about Mellenthin. It's a delightful case, and not only for Mr. Mellenthin, but those of us in the defense bar. But one interesting comment arises out of it, and it's been overlooked by some, and that is that in the court's analysis, they had to deal with not only the shining of the flashlight into the car, which they said was necessarily incidental to the stop itself, and that was unproblematic, but also the interrogation or the questioning about the gym bag in the car before any search took place. And the Supreme Court of Canada characterized the interrogation, in other words, the questioning itself, as part of the search and seizure. Now that's important because, as we'll see down the road, questioning in the context of investigation may have some Section 9, does have Section 9 implications, but within the context of Section 8, the police have a higher onus. The police have to demonstrate reasonable and probable grounds. So from the perspective of the defense bar, it's important to envelop police conduct within the Section 8 umbrella, which imposes this higher standard upon the authorities, and the Supreme Court of Canada did precisely that in Mellenthin. So it's an interesting issue. Many issues are still unresolved as a result of Mellenthin, but what would happen, for example, if the interrogation was not followed with an actual seizure that was significant in the criminal trial? Could a Section 8 analysis apply to the interrogation itself without the seizure that followed? That question is still up in the air. But I'd ask you to consider, when you're looking at your fact situations in your individual cases, how broadly the umbrella of Section 8 can be extended.
I think that the first case that analyzed, to my knowledge anyway, that analyzed Mellenthin was a case of our court in Machiavelli, which I think that if you get involved in this problem, you should have a close look. And the decision was written by Mr. Justice Carthy. And Carthy expressed the view that Mellenthin had brought in a fresh focus on the question of real evidence affecting the fairness of trial. The facts in Machiavelli were very close to the facts in Mellenthin. This was a very zealous police officer who stopped somebody for speeding and then asked to look in a bag and then look at a gum wrapper and search the vehicle, and finally he came up with some drugs. And Mr. Justice Carthy also discussed that the evidence, although real, could never have been discovered but for the illegal search. And he specified that Mellenthin should not be restricted to random searches or to searches that at a roadside stop. And the part that I think that is important is with respect to whether or not the evidence that was found rendered the trial unfair. And he was of the view that the real evidence should be equated to compel testimony. And this is something that I picked up in Zamet that we'll probably have a chance to discuss after the next question. The second question that we have on our program is it clear that warrantless searches of motor vehicles can and do occur in situations other than random roadside check stops? And that's up to you.
Okay. Well, as you've heard from Renee, when a vehicle is stopped for a random search or stopped for a legitimate driving violation, it could be contended that some search necessarily incidental to that legitimate stop is warranted. But Mellenthin basically says that that kind of search activity has to be very significantly circumscribed and related directly to the legitimate motivation for the stop. But there are circumstances where warrantless searches and seizures are permitted other than in that context. Now, the two scenarios that I put to you are first the Plainview Doctrine, with which many or all of you are familiar, and which our court has referred to, the Supreme Court has referred to in Mellenthin, and a variety of appellate courts have made reference to. Now, the Plainview Doctrine is sometimes misunderstood because it is contended by police officers that whatever the legitimacy of their initial stopping of the vehicle or initial intrusive activity, once they see contraband or stolen property in plain view, for example, within the vehicle, the Plainview Doctrine justifies its seizure. And that's just not so on the authorities. The conditions for the application of the Plainview Doctrine were set out in a case in the New Brunswick Court of Appeal, Bellevaux and Lossier, and they appear to conform to American doctrine and other jurisprudence in the area. And they've set out three criteria. First, the officer must lawfully make an initial intrusion or otherwise properly be in a position from which he can view a particular area. In other words, it has to be legitimate that he is in a position to obtain a plain view. He has to get there lawfully in the first instance. Second, the officer must discover the incriminating evidence inadvertently. In other words, he must not know in advance that the evidence is there. And thirdly, it must be immediately apparent that this is evidence of a crime. In other words, it has to be so plain on its face that one doesn't require further investigative efforts to determine its relevancy in the context of a crime. Now, what's important in that analysis is that, for example, and this is the most common scenario, speaking for myself, that a defense counsel faces, where a colorable stop of a vehicle occurs. In other words, police officers who have suspicions directed towards an individual stop a motor vehicle under the pretext of a driving concern or a random stop, then they will disqualify their conduct from the plain view exception. It's not inadvertent, and it's not a lawful initial intrusion or a lawful initial position from which to view the object. Now, apart from the exception of the Plainview Doctrine, of course, it seems clear that a warrantless search can be effected in circumstances where there are reasonable and probable grounds to believe that a crime has been committed and an object within the location affords evidence of the crime, and where it is otherwise not feasible to obtain a warrant. Well, that's important. I'll come back to that in a moment. But, for example, you have legislative enactments, such as Section 10 of the Narcotic Control Act, that permit the warrantless search and seizure of motor vehicles to obtain drugs, but the Supreme Court of Canada, applying constitutional principles, have read into that section the requirement that a warrant is not feasible in the circumstances. Now, this is very different than the American approach, for example, which has carved out an exception for automobiles. They've said that a warrant need not be obtained in searches of automobiles. Here we've taken a different approach. Here we've said we recognize that there's less of an expectation of privacy in relation to our automobiles, and we recognize that a more persuasive argument can be made that exigent circumstances are such that a warrant need not be obtained when something is mobile, like a motor vehicle, but it's not a hard and fast rule. Every case will spin on its own facts. And that leads me to another delightful case, which is Zammit, referred to by some crowns as, damn it, it's Zammit.
And the defense doesn't refer to it as
no,
damn.
no. We like this case, my lord, and his lordship was the author of this case, and interpreting this case is like telling Picasso what his pictures mean, but I'll tell you briefly about Zammit because it is a very important case. The facts, very briefly put, are these. The accused was charged with possession of cocaine for the purpose of trafficking and simple possession of marijuana. The police had received a confidential tip from an informant that the accused was selling drugs. And the informant gave the accused name, address, and a description of the vehicle. And the officer confirmed those particulars about the accused, namely, there is an accused by this name, by this description, who has this vehicle, who lives at this particular address, and so on. But in essence, there was no evidence before the court to demonstrate that there had been any confirmation as to the reliability of that aspect of the information that implicated the accused in a crime. The officer had said that he found the informant to be somewhat reliable, but there was no substantive evidence tendered before the court to support that conclusion. And his lordship, speaking on behalf of the court, basically said that the Crown had failed to muster evidence such that a reasonable and probable grounds for the search had been demonstrated. The fact that there had been confirmation of the particulars relating to the accused didn't do the job, and the Crown, through the police, must disclose sufficient information to demonstrate reasonable and probable grounds that the accused had been a party to the crime. But we go on from there because what transpired is that the accused was the subject of surveillance, which yielded nothing of terrible significance. And then later in the day, as a result of further information from the informant, which was again unsubstantiated, on the record at least, the accused was later stopped by police officers in his car on a ruse that he had committed a traffic violation, placed under arrest, searched, and a quantity of marijuana was found on his person and cocaine within the car itself. Now, Crown Counsel had contended that because the search took place in a car, well, they can make this argument, my lord. They contended that because the search had taken place in a car, a warrant was not required in the circumstances, drawing upon all of the authorities that I've earlier cited. A car is mobile, exigent circumstances, and so on and so forth. And his lordship pointed up in the reasons for judgment that the police basically can't position the accused in the motor vehicle and then rely upon the lower threshold required to establish a warrant once you're placed in the automobile. In other words, there was nothing on the facts to demonstrate that the automobile was implicated in the offense together with the accused. They just waited until he got into the automobile to stop him. And the point is that the police couldn't rely upon the location of the search in those circumstances to justify their failure to obtain a warrant. And finally, as his lordship has alluded to, and we're going to come to in a moment, I expect, Zammit also has implications for subsection 24(2) of the Charter, and perhaps I'll reserve my comments on that until we get to that issue. Renee?
suppose the only comment I'd make concerns the first point that Mark made, and that was that the search activity that's permitted has to be necessarily incidental to the random stop or the basis for stopping the vehicle in a Mellenthin-type scenario. You may want to look at a case from the Court of Appeal for Ontario called GAE. It's cited in the paper. It was decided just a few months before Mellenthin, but I think the reasoning probably is still good law. It's a case where the fellow was stopped and taken into the police cruiser and told that the officer that his vehicle registration and insurance papers were back in the car. The officer went back to the car and asked the passenger who was in there to open the console and the glove compartment, and lo and behold, when the glove compartment was opened, there were narcotics found. In that instance, the Court of Appeal said, well, it's more intrusive than your typical check-stop procedure, but it was necessarily incidental to the stop which was at hand. And I think you can say that unlike Mellenthin, where the officer was actually searching for drugs, in GAE the officer was searching for vehicle registration and insurance papers and only happened incidentally to come across drugs. I think that's really the significant difference. So in terms of how far police conduct can go in terms of search incidental to check stops, GAE might be a very helpful case.
I wonder if I can just...
Sure.
I was just going to comment on one thing, and that is that GAE predated Mellenthin, if I remember correctly, and it would be my submission, which we won't resolve here, that GAE would be resolved differently had it been decided today, because I concede the points that Rennie makes in favor of that case, but nonetheless, it was a most intrusive seizure. And in my submission, a powerful argument can be made that notwithstanding the legitimate motivations of the officer, that search and seizure could not be countenanced as necessarily incidental to the activity that caused the stop at first instance.
Of possible interest in the analysis of evidence received from a confidential tip, you may have a look at Zamet. Really, there's nothing new in Zamet, but I tried to compact it. I've got a simple mind. It's got to make sense for me when I look at it, and I tried to compact what had been said by Mr. Justice Martin in DeBow. And, you know, whether the information is compelling, was the tip credible, and what was the corroboration by the police. I'm still happy about the way I put that together, but I caution you about something that I found very surprising in one of the 3 recent decisions of the Supreme Court of Canada of Grant, Plant, and Wiley. In one of those, on an application for a search warrant, a telephone call had been received from a Crime Stopper. Now, I would have thought when I wrote Zamet that if there was something that was unreliable, was a telephone call from a Crime Stopper, because you have no idea who the person is. You've never dealt with the person before. It has no insidia of credibility, of reliability. And Mr. Justice Sapinka said that to receive a call for a completely unknown person can be used if it checks out. In other words, if the person gives the information that there are drugs at 145 Queen Street, if the address exists, it's corroboration of the tip. Now have a look at that, because according to Mr. Justice Martin, that's the very thing that you should be avoiding, because it's maybe somebody who wants to get you in trouble and says, well, if I send the police at 145, you'll be in trouble. And that very example, I think, or very similar example, is used by Mr. Justice Martin. So we now know that in a situation where you apply for a search warrant, a tip from a completely unknown person, if it checked out, can be used. In all fairness, there were other factors that could lead to reasonable and probable grounds. So don't isolate that. As Mark said in Zamet, it was interesting to see the argument of the Crown that when the arrest was made, well, this man was in a car and could easily escape. But they had known where he lived all the way along. They knew where he worked. They could have stopped him between his place of employment and his car, but they decided to wait in the car, and it seems to me that it's only logic that because they wait to put him in the car, they shouldn't get any greater rights than if they had stopped him anywhere else. Under Section 24.2, well, we'll probably have occasion to discuss that later on, but I feel that I followed the reasoning of Mr. Justice Sopinka, and I suggested that the position of the Crown to admit hard evidence, real evidence, had been severely shaken by Kokesh. I said that the real evidence could not have been obtained except for the illegal search, and I stated that it should be treated the same way as coerced or involuntary testimony. It rendered the trial unfair because the accused was forced to confront evidence he would not have otherwise faced. Now, Ms. Pomerance in her paper will tell you that maybe Kokesh is out the window because of the new trilogy of cases of Grant, Plant, and Wiley. And these cases are certainly very helpful on many issues, and if I may state them very briefly. First of all, we know now that perimeter searches are unconstitutional. We know that Section 10 of the Narcotic Control Act can be read down and applies only in exigent circumstances when it would be impractical to obtain a search warrant. Whether search warrants are applied under the code or under the Act makes no difference, no distinction. Computerized record, no expectation of privacy. It certainly makes sense. Evidence obtained pursuant to a valid search warrant, may be tainted because, in those cases of an illegal perimeter search, and brings into consideration Section 24.2. If you think about that, I think that a shortcut could have been taken, and the court could easily have concluded that if you have all the necessary ingredients for a valid search, a perimeter search that adds nothing, doesn't taint anything, and doesn't bring Section 24.2 into play. They've decided to take what I feel is a more complicated way around what happened. Number 5, I've got listed the anonymous tip from a Crime Stopper. That is troubling. I don't know where that will lead. And if you take the trouble of reading the book, you may have some difficulty to justify that. If the evidence is real in nature, its admission would not render the trial unfair. Well, we're back to Collins, and we're now 10 years post-charter, and everybody knows about the charter now. The police, even the police, they know about the charter. And I would have thought that we were going in the direction that if evidence was obtained illegally, it ought to be excluded. Never mind the hard or the soft or the real or unreal evidence. Because it seems to me, and I'm speaking for myself only, and if you quote me, I'll deny that I said it. But it seems to me that in the great majority of those cases, when you listen to the Crown and then you write the judgment, you come to the conclusion then that Crown Counsel and the court are always trying to sanction unlawful police behavior. Time after time after time, the duty of Crown Counsel is to try and justify behavior that is, if not clearly illegal, very dubious in nature. And I would have thought that we were past that now, and that we'd say, we all know about the Charter now. Let's comply with it. And if it's evidence that's obtained illegally, I tried to do that a bit in Zamet at the end, but obviously I didn't succeed. The good faith of the officers is back into play. I thought that it was by the board, but it's alive again. And the real evidence existed, but it I'm not sure now what the answer is, whether or not if we can still stick with Zamet, except for one thing that I would bring to your attention, and it's at page 44 in Grant and Wiley. And I read that a couple of times last night, and if this is right, page did I say? 44. No, that's not it. It's in Grant. Which one is Grant?
This one here.
Right, this one here. Oh, here it is. Page 19 in Grant. The conclusion of Mr. Justice Sopinka. I agree with him, that's the Chief Justice McEachran of BC. I agree with him that the decision of this court in Kokesh is distinguishable on the ground that in that case the police acted only on suspicion, whereas here they had reasonable ground. If that's the ratio of that case, nothing has been changed in Mellenthin, Acchiavetti, and Zamet. To me, if counsel present the argument to a court as to whether or not these cases have brought in any new development, if you quote what Mr. Justice Sopinka said, that the only reason that these cases can be distinguished from Kokesh is because in Kokesh they acted on suspicion, and here there were reasonable and probable grounds, then I think we're in business. I know Renee doesn't agree. She may have comment on that later on. We'll go to our third question. So far we've focused on Section 8 and the limits it imposes upon police authority to conduct searches of motor vehicle. In Simpson, the Court of Appeal considered the issue as to when police are empowered to stop and detain motor vehicles and their occupants for investigative purposes. Renee?
The Simpson judgment is a very significant judgment in the Section 9 sphere. Traditionally, cases under Section 9 of the Charter have been concerned with arrests, whether an arrest detention is arbitrary, whether the officers had reasonable and probable grounds, and if not, how far away from reasonable and probable grounds their state of mind was. Simpson really carves out a whole new territory of Section 9 jurisprudence, and that relates to what can now be called investigative detentions. And I suppose, broadly speaking, one could define an investigative detention as a detention that falls short of arrest, that is based on something less than reasonable and probable grounds, and that the police have invoked in order to facilitate investigation into a criminal offense. The Simpson case itself involved a narcotics investigation. The officer had read an internal police memorandum that identified a particular residence to be a suspected crack house. There was no source for that information, simply the assertion that there was a suspicion. He happened to be on patrol one evening and thought out of interest that he'd drive by the residence. and observed two individuals leaving and getting into a car. The officer really had no information about these two individuals except the fact that they had left a residence thought to be a crack house. Nonetheless, he decided he would follow them in his vehicle and pull them over for investigative purposes. He testified that it was his intention to try to confirm the information about the crack house and perhaps obtain grounds for their arrest. The question, indeed, he did pull the vehicle over. He conducted a search of the male occupant of the vehicle and discovered cocaine. The central issue before the Court of Appeal for Ontario and Simpson concerned whether the stop of this vehicle and its occupants was arbitrary in contravention of Section 9 of the Charter. Mr. Justice Doherty wrote for the Court of Appeal for Ontario in this case and suggested that the starting point for the analysis ought to be an inquiry into whether there is a lawful basis for the detention. His lordship cautioned that the words unlawful and arbitrary are not synonymous, and the lawfulness issue will not always be dispositive of the Section 9 claim. But clearly lawfulness is very, very relevant when one is dealing with claims under Section 9 of the Charter. If a detention does have a lawful basis, if it is lawful, then chances are it's not going to be arbitrary, unless the law which has authorized the detention is itself arbitrary. And conversely, if the detention is unlawful, it's not necessarily arbitrary, but the unlawfulness will play a pivotal role in the assessment of whether Section 9 has been infringed. So this is the first question that one is to ask. And it is clear from Simpson that one answers this question by looking to two possible sources. Lawfulness may derive from statutory authority, or alternatively it may derive from the common law. And both of those sources of lawful authority were considered by Mr. Justice Doherty and Simpson. The Crown in Simpson placed considerable reliance on the Ontario Highway Traffic Act. It happened that Mr. Simpson was behind the wheel of his vehicle when he was pulled over. The Crown pointed to Section 216 sub 1, which used to be 189A, and that might ring a bell because it's the section that was considered by the Supreme Court of Canada in Labrosse. That section provides that a police officer may require the driver of a motor vehicle to stop in the lawful execution of his or her duties and responsibilities. The Crown said, well, duties and responsibilities aren't qualified. We have to assume that this means all manner of police duties and responsibilities, including the broad duty to prevent and investigate crime. Mr. Justice Doherty rejected this argument. He was of the view that the statute does not authorize all manner of stops, but really only those stops which are directly related to traffic safety. So the Highway Traffic Act can only be employed when one is concerned with the regulation of driving conduct. And in this regard, Mr. Justice Doherty placed reliance upon such cases as Dedman, Husky, Ladouceur, Mellenthin, and he concluded that the fact that the target of a detention is in an automobile cannot enhance the police power to detain that individual. And that really picks up, in some respects, on what His Lordship Justice Labrosse had to say in the Zammit case about the power to search. Mr. Justice Doherty went on to consider common law authority to detain, and it is in this regard that his judgment is perhaps most significant, because it appears that he has carved out a sphere of common law authority for investigative detentions in inappropriate circumstances. The analysis of Mr. Justice Doherty started with something called the Waterfield test. Waterfield was a case decided by the English Court of Appeal some time ago, and it was brought into the Canadian case law in the Dedman case in the Supreme Court of Canada. Essentially, the Waterfield test applies where the police conduct at issue is a prima facie unlawful interference with a person's liberty or property. Where that is the case, where you have a prima facie interference, you must ask two questions, according to Waterfield. First, did the police conduct fall within the general scope of any duty imposed by statute or recognized by common law? Was there a duty? And if the answer to the first question is yes, you go on to the second question, which is, Did the conduct involve an unjustifiable use of powers associated with the duty? Now, clearly, of those two questions, number 2 is going to be the really thorny one. That's going to be the one that's much more difficult to answer. Mr. Justice Doherty in Simpson suggested that one should answer that question with reference to the totality of circumstances. He posited a totality of circumstances test, which would require consideration of a number of factors. And among those factors listed by Mr. Justice Doherty were the duty being performed, the extent to which some interference with individual liberty is necessitated in order to perform that duty, the importance of the duty to the public good, the liberty interfered with, and the nature and extent of the interference. And it would seem from the judgment that his lordship contemplated that one would balance all of these factors. And at the end of the day, the extent of the interference with individual liberty must be proportionate to the nature of the police duty which purports to justify the detention. Mr. Justice Doherty went on to carve out a special rule which will apply in the case of confrontational detentions. And by confrontational detentions, his lordship indicated that he was concerned with detentions in which the police intend to bring the force of the criminal justice system against the detainee. So where someone is the specific target of a criminal investigation, their detention will be confrontational in nature. In this context, Mr. Justice Doherty introduced the concept of articulable cause. He held that where there is a confrontational detention, detention will only be justified if the officer has some articulable cause for detaining the individual. Now, articulable cause is clearly a lesser standard than reasonable and probable grounds. It's perhaps difficult to give it a precise definition, but it would suggest that the grounds must be capable of clear expression. And it would also seem that it must, at a minimum, bear some relationship to a reasonable suspicion of crime. So rather than having to have RNPG to detain for investigative purposes, it suffices if an officer has a reasonable suspicion. Now, Mr. Justice Doherty went on to emphasize that this doesn't end the matter, and articulable cause does not necessarily dispose of the Section 9 claim. It's a necessary but not a sufficient condition. Even if the officer has articulable cause, one still has to look at the totality of circumstances to assess whether there's a Section 9 violation. And his lordship cited some examples that illustrate the importance of other circumstances. For example, if an officer has a reasonable suspicion that sometime in the distant past somebody committed a property offense, that's not going to permit him to detain that person on a public street for questioning. In contrast, if an officer has a reasonable suspicion that someone just committed a violent offense and they're in flight, that may well give him justification for detention of this nature. So this is a thumbnail sketch of the Simpson Judgment, and I'm sure I haven't done it justice, but it is a significant case in the context of Section 9, and no doubt will be relied upon by the Crown in future cases of this nature.
30 seconds.
30 seconds, just two brief comments. This is a very, very difficult case to get one's head around, and one should read it very, very carefully. But 2 points. I think you see now why I said earlier on that where Section 8 concerns and Section 9 concerns obtain in a case, it's important from the perspective of the defense to envelop the entire conduct within a Section 8 umbrella, because here under Section 9 we're dealing with reasonable suspicion as opposed to reasonable and probable grounds, so that's significant. Secondly, from the perspective of defense counsel in particular, don't forget the right to counsel, because whether or not the Crown succeeds on a contention that there was articulable cause such that investigative detention was justified in the circumstances, the Crown still has to meet the argument that the right to counsel had to be afforded for the detention in the circumstances, and often that is not the case in these kinds of situations.
On that note, we didn't cover half our program. Like typical lawyers, we didn't give a very good estimate of time. Thank you very much.
I'd like to thank the members of the panel. Particular thanks to Mr. Justice Labrosse, showing again the power of the Ontario Court of Appeal to comment on matters and ask you to exclude it from your mind as soon as you leave this building. I'd ask Mark Mahoney to come up next. He's our next speaker. To tell you a little bit about Mark Mahoney. Mark Mahoney has been in private practice as a criminal defense lawyer in Buffalo for the last 18 years. He's past president of the New York State Association of Criminal Defense Lawyers and a director of the New York State Defenders Association. Some of you may be aware that Mark has been involved in the past in organizing a program in Buffalo known as Cross-Examine to Kill, a program that I attended a couple of years ago and can tell you now I can cross-examine to commit serious bodily harm. Mark actually is a great friend of the Canadian Defense Bar, particularly those practicing in Southern Ontario. He is regularly available to be able to provide you with assistance on current and relevant U.S. authorities, and I personally have benefited from it, and we have indirectly, because in the Burek case referred to, Mark provided some cases on the tainting of witnesses and significant authority that actually became part of Mr. Justice Glithrow's reasons for judgment. To give you an idea of Mark's unique interest in Canadian jurisprudence, he even has with him today computerized printout copies of the decisions in Grant, Plant, and Willie, which none of us have. So, ladies and gentlemen, Mark Mahoney speaking about the American Constitution in the 1990s.
Actually, what Jeff didn't understand is when he called me up in the middle of trial, frantic, and thinking that the only person that could help him was me, saying, there must be some American authority that will help me in this situation. And doing what the only responsible thing I could do is I made something up and gave him a citation which I knew would never be able to be tracked down, and obviously he succeeded in persuading his trial judge that there was something to it. And then he reported back to me later on, this is now going to be embodied in the court's decision, and I wondered when the chicken's going to come home to roost on that one. No, actually it was real stuff, but somewhat outdated, but the language, I think, is what was appealing about it. In some respects, I feel in the position of a Starfleet officer who is plopped down on a planet and challenged with the question of whether or not to violate the Prime Directive by telling this species what their future is. Because a lot of the discussion today has been very much deja vu for me. It would be reminiscent of some of the exact topics that we might have talked about at our continuing legal education program, say, 10 years ago. Because many of the issues that you're confronting now are precisely issues that have been covered. The language that's being used is sometimes artfully disguised to avoid the American precedent. On other occasions, it's explicitly recognized where some of this language comes from. But yet, in a very important way, the ground that you are covering now in articulation of what the Charter means and what the terms of the Charter, how they should be interpreted, very strongly parallels another thing that is happening in the United States now that I'm not sure that Canadian counsel are clearly aware of. And so the first thing I'd like to do is draw for you a little bit of the historical background of, hopefully in a brief period, of how the evolution of rights came about in the United States, such that we had this body of case law that's a fruitful source for plunder at this point in articulating what the rights may be or may ought to be under your charter. And the reason I do that is not out of abstract interest in the history of American jurisprudence, but because it may be important for you in looking at cases in the United States that are decided, especially in federal court and in state courts, to interpret what is meant by some of the procedural postures in which these cases arise and some of the language that's being used by the judges. I could have chosen, and I think that maybe it was thought that what I would do when I came here was give you new and better cases from the United States that will help you succeed as they helped Jeff in his case in your next argument, either about, especially about charter issues. But more important to me, as I have heard the speakers here today, and as I've thought about this issue over the past several years in my conversation with my friends up here, is the issue, not first of all, of the articulation of of constitutional doctrine under the Charter or under constitutional law. What is the process by which we articulate what that body of law is? It's clearly not going to be locked into what the law was in 1982 when the Charter was adopted, just as in the United States. It's not, despite a lot of debates about original intent and so on, it's not what the law was or the conception of the law was at the time of the 1791 adoption of the Bill of Rights in the United States. It's got something to do with the evolution of principles of justice and the evolution of society. Now, what happened, the other aspect of what I'm interested in is not so much the articulation of those principles, because in Canada you have now, as has already been mentioned, some of the statements of constitutional law or of rights under the Charter are much broader than they are in the United States, and the area of search and seizure is one. And I don't think I'd be risking much by saying that the area of disclosure, even at the present time, you are ahead of most of us. I just completed in August, I completed an 8.5, 9-week trial, a racketeering trial, in which the most significant issues in terms of conduct in which my client was supposed to have engaged, the existence or the truth of that or not being determinative at the trial, that conduct of the accused was something I was totally unaware of until we had gotten disclosure the week before trial began. And so after preparing for this trial for about 1.5 years, it wasn't finally until a week before trial began, when we got about 4,000 pages of material from the government, that we finally understood what it was that the accused was charged with. And in fact, it was the non-existence of that conduct, our proof that it didn't occur was what resulted in acquittal after an 8-week trial, but we had that short period of time to deal, to really make use of that information and conduct our investigation. So part of the message here is the message that I guess I could put it another way. After years of shameless envy of the United States and its popular culture and our suppose our in some respects our law, Canada now is caught up. You now have the World Series, I congratulate you, and you have many people rooting for Toronto down in the Buffalo area. I can assure you of that. And you have the exclusionary rule. I remember years ago when I was a young lawyer, there was an equally young, well, not equally young, much older, but still at the time young Toronto attorney named Alan Gold, who came down to watch me argue an appeal in our appellate division in Rochester, New York. And Alan and I had talked about this case. It involved eyewitness identification. I made the first appellate reference, I can be confident, to the Devlin report, which was rather fresh back at the time, on eyewitness identification. And I led Alan by the hand into the courtroom, and he's, of course, very awe-inspired by being present in this American court. He has, well, even at that time, was very interested in the rules of law being espoused down there. And he was shocked and horror-struck by the fact that the argument of this appeal, a very significant case, lasted about 10 minutes. And of course, the tables were turned on me when I watched Alan argue a number of causes and saw how they would go on and on and on and essentially retry the case, it would seem, in front of the appellate judges of extreme patience. It's a two-way street. There, on the one hand, now that you've got the exclusionary rule, you see that however good the black letter law might be on what the rights might be, there are these interstitial questions of how we decide these issues, how they are reviewed on appeal, which are really, in the final analysis, the critical question in the evolution of individual rights, and whether or not a declaration that the perimeter search is allowable or not, we can see from Grant, Plant, and Wiley, doesn't necessarily matter if the court later on figures out an excuse to balance away the rights of the accused and say that otherwise the interest of justice would be served by letting the evidence in anyway. So I'm interested in the process by which we articulate constitutional claims and the rights, and on the other hand, more importantly, the process by which we adjudicate them, because there are strong parallels in what's happened and is happening in the United States. Let me in a general sense, outline what the evolution was in the United States. There was a time when the exclusionary rule was a matter only of federal law. It was applied in federal courts for federal offenses. And the states, by and large, did not exclude evidence that was obtained unlawfully. They were bound to enforce the Fourth Amendment to the United States Constitution relating to unlawful search and seizure, in the sense of, in a much more abstract sense that that simply it was not lawful, but the remedy of exclusion of the evidence was not applied in the states. It wasn't applied to the states until Mapp versus Ohio, which occurred in 1960. And the reason why Mapp versus Ohio occurred and why the Supreme Court began getting much more involved in requiring states to enforce or provide remedies for violations of constitutional rights had to do with what was going on in the United States at that time. The civil rights movement gave to the judiciary the recognition that there was unequal enforcement of rights in different parts of the country, and that minorities were being subjected more to police intrusions than other citizens. And maybe it was the disrepute of the law that was coming into play there that eventually federal courts became more active. And finally, in Mapp versus Ohio, said states are bound to apply the exclusionary rule as well for illegally seized evidence. In doing that, I think it's important to understand that this was part of the process of incorporation, which is very similar to the argument that was being made earlier about the role of Section 7, that the mechanism for getting rights that were considered to be federal rights to be applied in state courts was to say that the Due Process Clause of the 14th Amendment to the United States Constitution incorporated certain other rights. And so that it was by virtue of incorporating into the concept of due process the right to be free from unreasonable search and seizure, the right to have counsel, the right to effective assistance of counsel, the right to compulsory process, and all these rights were incorporated to the Due Process Clause, which explicitly regulated the activity of the states. The argument was made all along, as I outline a little bit in my paper, the argument was made all along by Justice Harlan on the Supreme Court that we ought not be getting into the business of dictating to the individual states who have their own constitutions, all of which or most of which antedated the United States Constitution and antedated the Bill of Rights in 1791. We ought not to be dictating to individual states what the general rules of constitutional criminal procedure ought to be. States ought to be allowed to experiment on their own with the level at which they want to protect individual rights under their own state constitution. And Harlan made the argument that the danger here is that in taking a particular doctrine and trying to articulate limits on the police, and this is primarily what we're talking about at this stage, limits on police conduct, and making it applicable to all the states, is that there will be a leveling effect, that in order to accommodate the interests of all the states, in order to not leap too far forward, there will be a natural tendency to dilute the meaning of the federal rights in order to make the states adhere to them as you're dragging them kicking and screaming along into ever increased protection of individual rights. So there was this debate in the Supreme Court in the 1960s and 1970s having to do with the rate at which and the extent to which the federal courts in the United States ought to impose upon the states the obligation to protect these rights to the same extent that they were protected in federal court. The argument for incorporating these rights into the notion of due process essentially won out over a period of time, but that really didn't prepare us in the states for the development where the Supreme Court, as you all are very, very well aware, eventually under Rehnquist and really eventually beginning under Berger as our chief justices, began retracting on the level at which federal courts were protecting constitutional rights. And so that you had a number of cases where, for example, a good faith exception to the warrant requirement or the exclusionary rule, inevitable discovery exceptions to the exclusionary rule, where the federal court began retracting on the level of protection of individual rights. The answer to this development began with a lot of opinions by Justice Brennan on the Supreme Court, who kept reminding individual states and attorneys in individual states and the highest courts of individual states that they had their own constitutions, and that under their own constitutions they could determine what the scope of protection of individual rights would be. And so we had this development of state constitutional law in what has been described in some of the literature as the new federalism. And it's a process whereby individual states and the highest courts of individual states say, yes, the Supreme Court says that, in the case, say, of a vehicle search on the highway, that if a person is legitimately stopped for a traffic infraction, the police can search the passenger compartment of the vehicle. The state is free to say, as New York did in New York in People versus Belton, that the police are only allowed to do a search if it's consistent with the purposes of the arrest, for maybe looking for alcohol in the car where there's been a stop for driving while intoxicated. So that we now have in practice in the United States, attorneys practicing criminal law have to be aware of two constitutions, the federal constitution and the rights which may be embodied in that, and the state constitutions, which by and large are now providing more protection for individual rights than you will find in federal court. To illustrate this process for you, I have set out an outline of some of the New York State doctrine, New York State constitutional doctrine. And I use the term constitutional relatively loosely because New York State has a rather humble document as its own constitution. It mixes in some rather lofty phrases about equal protection and due process with restrictions on divorce decrees in the one section after the other. And it has provisions there are provisions relating to speedy trial and right to counsel and right to compulsory process, which are found in our New York State civil rights law. But taken as a whole, I think it's although frankly the Court of Appeals in our state has not had occasion to be very explicit about this, that embodies the fundamental doctrine of that would be considered New York State constitutional law. I've set forth for you a number of these state decisions in different areas, in some cases comparing them with the way federal provisions are interpreted. And bear in mind, of course, that sometimes the language of the provisions are exactly the same. The rule against unreasonable searches and seizures in the New York State Constitution is precisely the same as the language in the Fourth Amendment. And there are some other minor variations in other provisions. But this has nevertheless led to a debate among our Court of Appeals and the Court of Appeals in every state, the highest courts of every state, as to how is it that we can rationalize reaching a different result under our state constitution than is found in the federal constitution when the language is exactly the same. So you'll see in cases in the states, especially in state court cases, debates about rationales for departing from the meaning given to certain provisions by the federal courts when the state wants to reach a different interpretation of the same language. A lot of this has to do with looking at, just as you might look at pre-charter cases here, common law doctrine, we look at cases which were decided prior to the time that federal rights were incorporated into the Due Process Clause before states were explicitly bound to apply the exclusionary rule, and so on. This process, the upshot of this process is that when you look, as you often do, and I can tell you certainly that it's much more often than attorneys, at least up to this point, from the United States have looked up to Canadian law. However, I think that's going to change as we get some newer principles articulated here, and it certainly has. I had a matter in our Court of Appeals where I was amicus involving our New York State's rape shield statute, and I had a whole section on the Speyer decision, and which was, by the way, unfortunately totally ignored by our Court of Appeal. But the fact of the matter is, I think that you may find that attorneys in the United States begin to seize upon some of the better developments up here. But when you look to the United States law, the law in the United States, my initial suggestion to you is that you look not just for federal cases or Supreme Court cases. In fact, the incidents where a decision out of the United States Supreme Court is going to be truly helpful to you, I think, are going to be the rarity and the rare cases as time goes on. Although I've pointed out in my materials a couple of cases that were relatively recent, and in some areas, our area of compulsory process, which is, if that would be the same as the right to give full answer in defense, but we have it explicitly stated in our Constitution, the right to compulsory process, and the articles by Professor Weston, which I think many of you might find very interesting as you pursue Section 7 charter claims with respect to the right to discover favorable evidence, the right to bring evidence into court and compel evidence from the prosecution. Professor Weston's articles on the compulsory process clause, which I've listed in my materials, outline the history of compulsory process in English and common law history apart from the American Constitution. So some of that material might be helpful to you in considering how to interpret Section 7 insofar as the right to present a defense. In any event, I suggest to you that the idea as you look to American law is to not just look at federal law and federal law from the Supreme Court, but to begin to pick out those states and those state courts which have announced doctrine which is going to be more favorable to you. And what is happening is, as those of us in the states are doing this process whereby we go to our New York State Court of Appeals and we say, look, this is the law as it ought to be. And isn't this what charter litigation is all about at the present time? You're having not been encumbered by, as say the federal courts have been, by years and years of evolution of doctrine, each bound by earlier precedent. You're at a stage, even though you're only, you still have 10 years under the belt under the charter, you're still at a position where you can make the argument that this is as it ought to be. And this is exactly what we are doing in the state courts in the United States. We're going to state courts and saying, look at this decision that the Warren Court made regarding search and seizure. This is as it ought to be, and here's the reasons why. And we're going to talk a little bit about that process here of the articulation of evolving constitutional doctrine. And what I'm telling you is that there is a very strong parallel that we all can benefit from between what you are doing and what counsel is doing in Canada under the Charter and what we are doing in the state courts in the United States in trying to articulate evolving principles of New York State or individual states' constitutional law. And so there's a direct parallel between the effort that you are going through and the effort that we are going through. And if you look to that process, I think you'll find a very valuable reservoir of information. There are journals that are devoted to state constitutional law. It's something which is very important both in civil and criminal practice in the United States because more and more state courts which have to decide constitutional questions are, now that they're accustomed to doing it under in federal cases, they're beginning to look at state constitutional doctrine and the state constitutions in deciding what the boundaries are of civil rights. Just as an example, forced medication of psychiatric patients. That leading case in that was decided in New York State, not under the federal Constitution, but strictly under the New York State Constitution. So my first message to you is that as you look south, not to look south to the United States for helpful doctrine. Think about the state courts and state court decisions. And I think that actually Michelle First does a great job in her column in the newsletter of the Criminal Lawyers Association in bringing out highlights of some of the more interesting decisions. And virtually half of the decisions that she usually refers to are state court decisions. And I think that that's the right track. And that's what I encourage you to look at. Now, that is to say that I am not really coming from the future. I'm working with you in the same trenches now on the same issues, trying to get our courts essentially to do the right thing in articulating constitutional doctrine. What we do have experience in, and what reading, for example, the three decisions that were decided on September 30th from your Supreme Court, that just as we're at the point where we have certain constitutional doctrine established, maybe some of it's clear from the Charter, maybe some of it is evolving or implied or incorporated into terms such as Section 7, we also have the process by which these rights are adjudicated, the way they are decided at the trial level, the way they're reviewed on appeal. And what has struck me is that there are archetypes by which judges, either at the trial level or at the appellate level, circumvent the enforcement of constitutional claims. I'm much indebted to Justice Labrosse for his comments about the appearance that those who are, that the only, I've often felt this myself, the only one who's there to enforce constitutional claims is the defense attorney. The job of the prosecutor, and increasingly it seems, certainly in the United States, the job is not to articulate how the Constitution is to be enforced, but why violations of the Constitution are to be overlooked. And we see in the United States certain archetypes that develop of the means by which judges and at the trial level and at the appellate level circumvent constitutional claims. It's enough to say we would have thought that the perimeter search of a house is not constitutional. It turns out that's not enough to say. So the first is whether or not, when a matter comes for review, a constitutional question, I'll take as a better example of this the question of whether an evidentiary ruling was made at the trial level to exclude evidence of the prior sexual history of a rape complainant who may have made either engaged in conduct or made certain claims in the past that are sought to be excluded under a rule of evidence. And a judge decides that that evidence is not to be admitted. What is the standard of review of that judge's determination? It's been very customary for courts in the United States to say that questions of the admissibility or not of evidence are matters committed to the sound discretion of the trial judge. Now, I make a different argument that when, if one has the right to present a defense or the right to a full answer in defense, however you want to put it, then I have the right to the admission of evidence notwithstanding traditional rules of evidence so long as that's material to my claim and that there's some reasonable basis on which the jury or the fact finder could evaluate the weight that should be attributed to that evidence. And so the argument is made that the right to compulsory process, the right to present a defense, means that certain rules of evidence are not applied equally to the defense as they are to the prosecution, and that there is not parity to the trial rights of the accused with vis-a-vis the rights of the Crown. Now, if that's true, if there is a constitutional right to bring in evidence, notwithstanding a particular rule of evidence, say hearsay, then that means that the trial judge is making the decision on whether or not to allow that evidence is not making a traditional rule of ruling on evidence. The judge is not making a traditional ruling regarding a normal hearsay question or whether this witness is qualified to offer an opinion. The judge is making a ruling on a fundamental issue of constitutional law or an issue of fundamental right. And I raise the question, not in a novel sense, but I raise the question to you as to whether or not a trial judge should have the exclusive discretion to finally decide constitutional claims, and whether or not a trial level determination that affects fundamental rights must be reviewed de novo by the appellate court. Otherwise, the enforcement or not of fundamental claims of right is going to be left up to the discretion of a trial judge. And so the first section the second section of my paper that I presented to you is some arguments that have to do with when is it appropriate for a reviewing court to treat trial level rulings as discretionary, and how it's not appropriate to do that when those trial level rulings are rulings that affect fundamental rights. And looking at the again, you need to go no further than the Grant, Plant, and Wiley judgments to see that how the question of whether review at the appellate level is de novo or not is a device by which appellate courts can abrogate from the responsibility to decide those claims. A similar type of situation occurred in our decision in Gates versus Illinois of the United States Supreme Court. Gates versus Illinois was a case which retreated from earlier standards about how to evaluate informer-based search warrant applications, where the informer says that the accused is not only guilty, but evidence of the crime is at a certain location. Prior to Gates versus Illinois in the United States, federal courts required under, you may be familiar with the Aguilar and Spinelli decisions, required demonstration not only that the informant was a reliable person, but that their information there are reasons to believe that their information was credible in this instance, and it was called the two-prong test for informer reliability. The Supreme Court stepped back from that and said, no, we'll look at the evidence as a whole to see whether or not there's probable cause without regard to these extra requirements. That was the big thing about Gates versus Illinois. But the other thing that most people didn't observe in Gates versus Illinois is that they also said that the decision as to whether or not the trial judge or the magistrate correctly granted a search or not had to do with not whether or not, as a de novo matter, that judge was correct, but it had to do with whether or not there was a reasonable basis for the issuance of the warrant. And you see I think it's in the Garofoli decision that's cited in Plant and in Grant, reference to this question of whether or not there's de novo review of these magistrate determinations of search warrant. And let me suggest to you what the problem is with this. If the courts that are issuing the final word as to constitutional law are not reviewing de novo these fundamental claims, then what you have is a continual dilution of those constitutional rights. If at one time the court says that although if we were on our own we're going to decide this, we'd say there was not probable cause for the issuance of this warrant, nevertheless the judge who issued this warrant had a reasonable basis to issue it, even if it didn't meet up to the standard of probable cause, that's all right. Well, the next judge who's confronted with a search warrant application on even less facts might look at that judgment from the Court of Appeals or the Supreme Court and say, well, since that case on those facts passed muster at that time, then this case probably passes muster at this time. So the standard that the judge issuing a new warrant would rely upon would be a diminished standard from what really should be the standard of probable cause. And all that is a result of the dilution of that standard, because the highest court is looking at these things not de novo, but by giving deference to what the original magistrate did. The other problem that I see, the other archetype for the circumvention of constitutional claims is this process of balancing, which again comes back to this issue of we would think it would be enough to say that if there's a perimeter search and a search warrant is obtained on the basis of that information, that should be the end of the question. And this remarkable process of balancing seems to get down to the question, or won't it eventually get down to the question, when considering whether the administration of justice is being brought into dispute, is whether or not that particular judge feels that their decision would bring them into disrepute if they were to allow this evidence in or not. And this extremely vague process by which any kind of consideration could be brought in to say that the exclusion of this evidence would bring the system of justice into disrepute is a very insidious process, which we have in the United States. It becomes, here it sort of is very explicit in your charter, or at least it's been interpreted to be an explicit permission to balance the rights of the accused against apparently almost any other right. And I think the job of the attorney, the ideas that I can suggest to you in changing this balance a little bit, is to talk about what our rights are proper to balance against what other interests, and to investigate and to begin to establish an empirical basis for the argument that any time evidence that's illegally seized is allowed into court, that itself will eventually bring the system into disrepute. And to point out, as we have in cases that I have handled, point out if the standard that the police are given to enforce is something less than probable cause, if it's simply enough that the magistrate wouldn't be overturned for issuing a warrant, if the standard becomes less and less, and we have more and more mistaken searches, more and more instances of police entering the wrong premises or entering a premises at the wrong time. We have these cases all the time, and I'm sure you do too, where they enter the wrong place. Maybe somebody gets shot. Maybe they break into an innocent person's house, and when you begin to go through the process of tabulating, how often does that occur? We begin to see how lowering and not enforcing in every instance the standard of probable cause in the issuance of warrants has an impact of making innocent persons more subject to improper and unreasonable intrusions, with a risk to life, not only of police officers but to citizens who are not engaged in drug activity, who have their house burst into in the middle of the night by officers executing a warrant that's been mistakenly obtained have more of a reason to think that they are endangered by the people entering than those who are engaged in criminal conduct and expect that if anybody's breaking in, it's going to be the police. Making these kinds of arguments about the societal cost of the police not obeying the law is what's necessary for you to begin the process of putting a limit on the balancing process of balancing away the rights of the accused. I think that those are the main suggestions I have for you. I've made some suggestions here as to a recent case in Maryland versus Craig in the Supreme Court, where Justice Scalia came out against the process of balancing individual rights against the rights of society. And hopefully that'll be a clue to you and help in challenging what I see to be the more insidious and dangerous process going on in your courts now, and has not to do with inadequate statement of what the rights are, but a process which is inadequate to guarantee that those rights are going to be enforced as time goes on. And hopefully those pointers will, maybe I'll be able to look later to proceedings in Canada, not only for better statements of the underlying doctrine of individual rights, but maybe eventually you'll be of assistance too in overcoming this process of balancing away individual rights against abstract rights of society. And I guess my time is up. Good for you all, and thank you.
Thanks very much, Mark. Well, I trust that this morning has given you ample food for thought. We have the opportunity now to get food for the stomach. We've got an hour, roughly, if you can come back for 1:30, and we have presentations for this afternoon on charter procedure and on remedies, and we look forward to starting as close to 1:30 as possible.